Another one of the American Bar Association's finest, accredited attorneys, endorses violating the U.S. Constitution. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today, ladies and gentlemen, we're going to have a standalone lecture regarding a recent interview between ABA accredited attorney, currently practicing attorney, Will Chamberlain, and Piers Morgan. It also co-hosted or involved Mr. Owen Schroyer and Summer, well, I'm going to forget her last name, but it was a panel of 4 people in total, including Mr. Piers Morgan. And the question came up about the current administration, the current U.S. administration's practices, tactics, and antics going on in Iran. Piers, in passing, mentioned, well, you can, if you do war things or if you do war acts, but don't call it a war, then you don't have to get approval from Congress. To this, Will Chamberlain provides this argument.
I mean, I think it's a war. I don't know what the legality of it is and why the president might want to avoid it. You know, he might want to say, to use the language,
well, he doesn't have to clear it with Congress, does
powers.
If you don't call it a war, you don't need congressional approval.
Right, but then we don't get to do things like knock out 50 of the Iranian leadership in the first 5 minutes of the war, right? We lose the element of surprise. This is, this isn't 1760s where there's no telephone communication across oceans. The sooner England hears about our wars 3 weeks later when a ship shows up, instantly the moment we declared war, the Iranians would know what's up, and that would be the end of our ability to gain the element of surprise. And that saves American lives. If we're going to do a military operation, I think that we want the commander-in-chief to do so in a way that minimizes American casualties to the extent possible. And so I think that it's totally justified for him to do that.
And frankly, we shouldn't be surprised because it's typical fear-mongering by tyrants, not just ABA-accredited attorneys, but tyrants in general. Well, if we don't do it this way, we're going to get killed. If we don't do it this way, we're going to lose. It's constant fear-mongering. It's probably the #1 tool that authoritarians use whenever they want to instill or implement their ambitious and tyrannical authoritarian agendas and beliefs. So first, I want to say, what is the point of having any sort of accreditation if the accreditation leads to producing attorneys like this who openly advocate against the clauses and the statutes contained within the U.S. Constitution? What's the point of having accredited lawyers if the lawyers aren't applying legislated and implemented laws, more importantly, that are in pursuant and compliant with the U.S. Constitution and the respective state constitutions? It's one of the reasons the Calhoun School of Law is very happily, very self-proclaimedly not accredited by the American Bar Association, because look at what they produce. Now, this isn't to hearken on Will Chamberlain himself. It's to challenge the very ideas and the very curriculum that he was forced to accept, forcibly indoctrinated with, and extorted, used to coerce him by leveraging his future career in law. So you either comply with this ahistorical, unconstitutional curriculum that is masquerading as a law school curriculum, or you don't get to practice law. And that's one of the very large reasons why, 1, the Calhoun School of Law was formed, and 2, why we are very proudly, very self-proclaimedly not accredited by this self-proclaimed Marxist accrediting agency named the American Bar Association. So first, real quick, almost as always, let's check the U.S. Constitution and see exactly if Piers Morgan is right in saying the right to declare war, the power to declare war, is granted exclusively to Congress. But in short, it is. So we can look at Article 1, Section 8. Article 1 is the one, or is the article, I should say, the article that details the Congress, the U.S. Congress. Section 8 details all of the powers that Congress gets to exercise, which means everything that's not included in Article 1, Section 8 is thereby retained to the states. If you want more receipts, if you want historical backing for that position, just ask down in the comments. I have a very long laundry list of primary sources from the founding generation that proves that principle to be the case. It's called Inclusio Unius est Exclusio Alterius. We did do a lecture on it about 4 or 5 months ago now. If you want to go watch that lecture, I would encourage you to do so. But that's the Latin legal maxim that the founders referenced and used whenever they were going about drafting the very limited, narrow enumerated powers of the U.S. government. Anyway, Article 1, Section 8. I went on a whole monologue there. Article 1, Section 8, I think this is clause, what would that be? Looks like maybe 10 or 11. Let's do a quick count. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Look at that. So clause 11 says to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. Well, Caleb, going to a foreign land and bombing their nuclear weapon centers, going to a different country and kidnapping their leader, going to a different country and helping another country wage war against that country, none of that's actually declaring war. When we try to, these aren't war acts, Caleb, even though if we had those very same things done on us, it would absolutely be declared war. It would absolutely be a war act. Well, let me show you a couple letters from the founding generation themselves in which they say directly to the opposite of that. What we're doing right now, what we did in Venezuela, what we did in Iraq, what we did in Vietnam, all of these different acts that we kind of haphazardly just say, yeah, that can be done, would not at all be legitimate or constitutional in the purview of the founding generation. So let's look at George Washington, what he has to say specifically about the power to declare war. So it's from Founders Online. This is a letter from George Washington to William Moultrie, 28th August 1793, from Philadelphia. He says, Dear Sir, I have received your letter of the 11th of the last month. Do keep in mind, this is George Washington, first general, first commander-in-chief, first U.S. president. His opinion matters a lot. Having conceived an opinion highly favorable to General Pickens, I invited him to repair to this city in order that I might obtain from him such facts and information as would be essential to an offensive expedition against the refractory part of the Creek Nation whenever Congress should decide that measure to be proper and necessary. When what? Whenever Congress should decide that measure to be proper and necessary. So these are people, this is a foreign nation on the same continent, on the same landmass, causing problems. Does Washington take up his sword and march against the Creek Nation? Nope. He awaits congressional approval. The Constitution vests the power of declaring war with Congress. Well, Caleb, we already know that. Listen to this next part. Therefore, no offensive expedition of importance, like killing 50+ leaders of a foreign nation, can be undertaken until after they shall have deliberated upon the subject. Who is they? He's referring to Congress. Upon the subject and authorized such a measure. It is essential, which is communicated to you in confidence, that under the present circumstances, it is not improbable that an offensive Creek war might bring on a war with an European power whose possessions are in the neighborhood of the Creeks. From recent information from Mr. C. Grove, it would appear that a considerable portion of the Creeks, particularly the Upper Creeks, were determined to make satisfaction for the injuries which have been done by that nation, but the bearers of this message were killed by a party of militia, the consequences of which time will develop. I have had just reason to be satisfied with the information of General Pickens, and if the time shall arrive when an expedition shall be directed, by whom? The Congress, I shall be greatly gratified by his taking an eminent part therein. I have the honor to be, with respect and esteem, dear sir, your obedient servant, General George Washington. Well, Caleb, that's just one of the founders, okay? If the first commander-in-chief, the first president, isn't a good enough example, isn't clear enough when he says no offensive expedition of importance can be undertaken until the Congress has approved it, how about the father of the U.S. Constitution, Mr. James Madison, when he wrote to Thomas Jefferson 2nd of April, 1798? He says this: Since my last I am in debt for you for your 2 favors of the 15th and 22nd, the gazettes of the 3rd, 6th, 7th, and 8th, with a regular continuation the 22nd. 2 statements from the Treasury Department and Payne's letter to the French people and armies. The president's message is only a further development to the public of the violent passions and heretical politics which have been long privately known to govern him. It is to be hoped, however, that the House of Representatives will not hastily echo them. At least it may be expected that before war measures are instituted, they will recollect the principle asserted by 62nd verses 37. In the case of the treaty, and insist on a full communication of the intelligence on which such measures are recommended. The present is a plainer, if it be not a stronger case, if there has been sufficient defection to destroy the majority which was then so great and so decided, it is the worst symptom that has yet appeared in our councils. The Constitution supposes what the history of all governments demonstrates, that the executive branch of power most interested in war and most prone to it. It has accordingly, with studied care, vested the question of war in the legislature. But the doctrines lately advanced strike at the root of all these provisions and will deposit the peace of the country in that department which the Constitution distrusts as most ready without cause to renounce it. For if the opinion of the President, not the facts and proofs themselves, are to sway the judgment of Congress in declaring war, and if the President in the recess of Congress create a foreign mission, appoint the minister, and negotiate a war treaty without the possibility of a check even from the Senate until the measures present alternatives overruling the freedom of its judgment. If again a treaty when made obliges the legislature to declare war contrary to its judgment, kind of like getting involved in the affairs of 2 warring nations, and in pursuance of the same doctrine, a law declaring war imposes a like moral obligation to grant the requisite supplies until it be formally repealed with the consent of the President and Senate. It is evident that the people are cheated out of the best ingredients in their government, the safeguards of peace, which is the greatest of their blessings. I like both your suggestions in the present crisis. Congress ought clearly to prohibit arming, and the President ought to be brought to declare on what ground he undertook to grant an indirect license to arm. The first instructions were no otherwise legal than as they were in pursuance of the law of nations, and consequently in execution of the law of the land. The revocation of the instructions is a virtual change of the law, and consequently a usurpation by the executive of a legislative power. It will not avail to say that the law of nations leaves this point undecided, and that every nation is free to decide it for itself. If this be the case, the regulation being a legislative, not an executive one, belongs to the former, not the latter authority, and comes expressly within the power to, quote, define the law of nations given to Congress by the Constitution. I do not expect, however, that the constitutional party in the House of Representatives is strong enough to do what ought to be done in the present instance. Your second idea, that an adjournment for the purpose of consulting the constituents on the subject of war, is more practicable because it can be effected by that branch alone if it pleases, and because an opposition to such a measure will be more striking to the public eye. The expedient is the more desirable, as it will be utterly impossible to call forth the sense of the people generally before the season will be over, especially as the towns, etc., where there can be most despatch in such an operation, are on the wrong side. And it is to be feared that a partial expression of the public voice may be misconstrued or miscalled an evidence in favor of the war party. On what do you ground the idea that a declination of war requires 2/3 of a legislature? The force of your remark, however, is not diminished by this mistake, for it remains true that measures are taking or may be taken by the executive that will end in war, contrary to the wish of the body, which alone can declare it. It is extremely clear, overtly clear, whether it be the first commander-in-chief, whether it be the father of the U.S. Constitution. Any offensive is an act of war, which has to first be declared by the Congress to be constitutional. Well, Caleb, what about Thomas Jefferson and the Barbary Pirates? I've been looking for the letter that details the exact arguments he made. I'm going to find that letter. I'll post it in the description. What Jefferson and Madison had discussed, I think it was between Jefferson and Madison, is by deterring, not even deterring, by immediately repelling a violent act, he's not declaring war, he is preventing a war from taking place. He had said in the letter, in essence, that going even one step further than that would have been a violation of Clause 11 in Article 1, Section 8. But because all he did, all the military did with the Barbary pirates was immediately repel their aggression, was immediately repel their violence, it was only self-defense. It was not an act of war. It was not an act of hostility. It was an act of defense. It wasn't a positive act as in starting something. It was a negative act as in ending something before it started. There was immediate aggression. There was immediate resolve for that aggression, and not one step further. That's it. So you'll hear these arguments from individuals like Mr. Will Chamberlain saying, well, if we went through the formal processes, then the other nations would know and we would lose our element of surprise. Okay, if you think that's true, amend the U.S. Constitution. You don't get to break the rules because of circumstances and unprecedented times, and because the founding generation didn't know of all the technological advancements in 1776 that would be made by 2026. If you're truly going to uphold that argument, well, then here comes the argument of all the people who want to pervert the second article to the Bill of Rights in the U.S. Constitution. Well, they only had muskets back then. Well, they only had letters. That means we get to reinterpret, redefine, and restructure without amending the, not just intention, the denotational purpose of Articles 1 through 10 in the Bill of Rights of the U.S. Constitution. You don't get to do that. You don't get to redefine the terms of a contract after the contract's been signed. You don't get to change midway. If you truly think the element of surprise, all of these different factors that you think are so critical to the general well-being of these United States, then you need to amend the U.S. Constitution. You don't get to break the rules because of circumstances, because of demanding times. You don't get to break the U.S. Constitution. Well, Caleb, what about Vietnam? What about what happened in Venezuela? The promise that was given by the administration, one of the big reasons so many people who had never voted before, voted for this administration was because it promised to be different. It promised not to do what past governments had done, what past administrations had done. The whole point of the electorate putting into power this administration was to not be like the people who conducted the unconstitutional war of Vietnam and all of the other examples that have been repeatedly mentioned. I don't think it would be worth time repeating them here. What about Vietnam War? Sure, it was unconstitutional too. Point being, any offensive without the approval of Congress is unconstitutional. Any offensive. If you think that's impractical, if you think, well, then you're just going to lose every fight, Caleb, you're going to lose every war, then amend the U.S. Constitution. Stop breaking the terms of the contract and then pretending like you're trying to uphold it. Stop breaking the rules. Stop violating the U.S. Constitution because of the quintessential number one excuse used by every tyrant in all of history, because of unprecedented times. Because if you don't do it, you're going to die. Because if you don't do it, we're going to lose our element of surprise. We're going to lose. Fear-mongering is for governments of men. It is not for governments of laws. You think we would lose using the process outlined in the U.S. Constitution, amend the U.S. Constitution, or admit the U.S. Constitution is faulty, which is a totally legitimate position to take. Just make it your position and stop circumventing making that admission. I think I've gone on long enough. I've already gone a couple minutes past what I wanted to. If you have any questions about this position, if you think I'm totally off my rocker here, maybe you have primary sources showing to the contrary, that the founding generation actually did want to vest all of this power, all of this carte blanche permission on the executive, go ahead and share it down in the comments. I'm more than willing to admit I'm wrong. The papers I've read through suggest to the opposite, that the executive is the least trustworthy of the branches with the power to declare war, to conduct any sort of offensive. But like I said, I've gone on too long. If you have any questions about this, maybe a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information such as this to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.